Hello, my name is Olivia Wan, and I'm an attorney here in Tennessee, also licensed in Kentucky. Today's video is about estate planning considerations. This video does not constitute legal advice or engage my services as an attorney. This is just a brief overview to familiarize yourselves with the different concepts and terms that we use in estate planning. Whether this information is for you, your family, or your aging parents and family members. Let's discuss some estate planning basics. It becomes challenging when we're working with blended families, where husband and wife both have children from prior relationships, and now they form a new family unit. We want to prevent families from feuding when one parent passes away. It may be there's concerns of estate taxes, or certainly protecting your assets that you've worked so hard to earn. A common question I get as an estate planning attorney is, what happens if I die and I do not have a will? Does the estate get everything I've worked for? And the answer is no. If you do not have a will, then your estate would be administered according to state law. So let's talk about Tennessee. So if you die with no will, the state would look at who your legal heirs are in distributing your assets. And so let's say you're single and you have no children and your parents are living, then the estate would flow upwards to your parents. If you're married with no children, it would flow to your spouse. If your parents are deceased and you're not married, it flows out to your brothers and sisters. If you have children and no spouse, it flows down to your children. Now, this can vary just a little bit depending on how long you've been married. In Tennessee, if you've been married more than 10 years, the spouse could qualify for the electing against the will, which is up to 40% of the net. When there's no will, there is an administrator appointed to manage the estate in distributing the assets. But is that really how you want your estate administered? Let's say this is your brother, and you have no children, and your estate would flow to a sibling. Is this how you want your estate to be distributed? So it's very wise to prepare a will so that you can choose how the estate is administered. Think about Prince. Prince was a very extremely successful celebrity, rock star singer, and he didn't have a will. And his estate ended up being contested. Family members arguing about a $200 million estate. Already, $45 million have been spent in administrative costs and legal fees as of spring of 2019. James Dean did not have a will. He died at just the young age of 29. His entire estate, including the licensing fees, passed to his father, who actually abandoned him as a child. The value of those licensing fees alone is between $1 million and $3 million a year. So having a will allows you to control how your stuff is distributed. Now in Tennessee, you can't cut your spouse out. And so you cannot have a will prepared to leave your assets all to your children or to someone else. As I mentioned earlier, the spouse can take the elective share, which based on the length of marriage could be 40%. Without a will, even if assets are titled separately, the spouse is entitled to a child's share or 1/3. This would not apply if there is a valid prenuptial agreement. You can, however, in Tennessee, cut your children out. So I've seen cases where children didn't visit their parents for Christmas or Thanksgiving or birthday, and the parents come in and ask me as their attorney to rewrite their will and cut their children out. And then when they make up at the next holiday, they're back in the will. And sometimes there's provisions made outside of the will. So maybe a parent left a child life insurance proceeds and they chose to leave the real estate to a different child. Or it could be that a parent chooses to leave a child out of the estate due to creditor problems, where a child's in excessive debt and they do not want their distribution to that child to end up soaked up into bills. Or it could be that child has a chemical dependency problem. So here's some ideas for families to keep them from fighting and feuding. Rather than language in a will that states, I leave my real estate and everything to my 3 children, perhaps it would be better to say, my real estate would be sold at fair market value and divided equally among my 3 children. And that prevents one of the siblings that's trying to move into the house and live there and expect the other 2 siblings to pay for the expenses of upkeep, utilities, and insurance. So think in your mind, what is an equitable distribution? Perhaps it's a farm, and one child actively works that farm and the other children do not, and have occupations that have taken them away from that property. So you may want to think about, how can I protect the interest of this child that actively works the farm and still allow an equitable share for these other children? So there are ways that we could meet your objectives as a family to provide for your children. Now let's think about provisions for that chemically dependent child or special needs child. If there's a chemically dependent child, it might be the last thing that you want is that child, who's now an adult, to come into your assets, whether it be money or real estate, and that is squandered on a chemical dependency problem. So you may want to think about allowing a life estate where that child could live in a home for their lifetime, but the remainder interest conveys to a different beneficiary. Or you can craft a trust, and there could be chemical dependency language so that the trustee can withhold distributions if that child is currently chemically dependent. Now, for a special needs child that's receiving government benefits, it would be in the best interest to prepare a supplemental needs trust so that when the child inherits, they're not coming into income or money that would disqualify them from such valuable government benefits. And instead, the will would send it over to a supplemental needs trust that can be used for expenses that are not covered by their government benefits. So here's a typical scenario that we get. There's a couple that's been married forever, long-term marriage, and they have accumulated these assets, stuff we can call it, house, cars, vehicles, furniture, what have you. And then one spouse dies. The surviving spouse is stricken with grief, and they're lonely, and they're brokenhearted. So let's just say, as an example, that it's the wife that passes first. And husband is lonely and associates marriage as happy because he was happy with his wife all those years. So here comes Party Polly, and she meets this older gentleman that's sophisticated and stable in his life, and they have a relationship and they choose to marry, and the first thing they do is they make an appointment with a lawyer to retitle the assets. Do you really think that Party Polly, when she survives her husband, will benefit his children? It's unlikely. That's why it's so important for the husband to have solid estate planning to assure the distributions he has in mind for his children. So that's the rest of the story in this example. The new spouse potentially could spend all the money and nothing is left for his children. and then the new spouse makes a will, leaving everything that now belongs to her because she's the surviving spouse of co-owned property and assets, she makes a will and leaves it to her children, not to the husband's children. So the surviving spouse then could be victimized by a gold digger, which is spouse number 3. And spouse number 3 ends up spending your estate. So how do we prevent that from happening? One way is an irrevocable trust or irrevocable trust. These are actual examples that I've run into in my practice. I've seen couples to come in and change their will. I'll give you an example. I had a couple, actually it was a gentleman, and his wife had passed away, and he wrote a new will. He had every right to do so because he was the surviving spouse. Well, the stepchildren weren't very happy when they learned that they were not the beneficiaries of his will. So if you are looking to prevent a spouse from changing the way the assets are titled, then it would be best to consider an irrevocable trust. When we discuss trust law, some of the clients feel like, well, that's just too complicated. I just want a simple will. I have a family member or have a good friend that knows what I want, and they will prevent any of those bad things you're talking about from happening because they know what to do. So do you have a trusted loved one? You better put it in writing. Name your beneficiaries. Do not leave everything to your personal representative, both as a beneficiary and the personal representative, or what you may refer to as an executor. Because nice Nancy, does she really know what you want? Or will she, once she becomes a beneficiary, retain it? So if you leave it to nice Nancy, Nancy might be saying, I'm in the money, and your money is gone. There could be unintended heirs. Let's talk about Marilyn Monroe. She died at the young age of 36. Her will left 75% to her acting coach, and that she thought he knew her wishes to donate to charity. Well, he later remarried, or married, and at his death in 1982, his estate plus Marilyn Monroe's licensing and royalty fees went to his spouse, who was a complete stranger to Marilyn Monroe. And those licensing fees generate about $1 million a year. So that's why we want you to think about your estate and the different variables that could happen. Now, some people say, well, I don't like dealing with lawyers. I don't like lawyers. I can just draft my will using something that I find on the internet. Who needs a lawyer anyway? Can you write your own will? Well, you certainly can. If it's a handwritten will, we call that a holograph. So all the material parts need to be in your handwriting. But let's talk about online wills, or wills in a box. I've had online wills to come through my practice that were not completed correctly. Had one will that came in, the will only referred to personal property and did not talk about the real estate. They didn't appoint successor personal representatives. Now, in the handwritten wills, don't forget to have 2 witnesses to your handwriting. And it can't be half typewritten and half handwritten. All the material parts must be in your handwriting. We've run into scenarios where the will was stolen and there was no secondary copy to be located. So when we write a will, we keep a scanned version in our encrypted electronic files so that if ever a will is lost or stolen, we have a duplicate available for the court. Now, with an online will, we've seen where people forget to waive the accounting or bond. As I mentioned, they confuse property and think that the executor will do the right thing. They don't think about chemically dependent children or special needs children. I'll give you another scenario. We had an elderly person that passed away, and he gave his estate to his 3 children. What he didn't think about was that one child did not have children. And so that 1/3 share, because the child was deceased, flowed over to her spouse. And that's probably not what he intended, that an in-law would inherit 1/3 of his estate because she didn't have children. Also, I had an online trust come through my practice where someone went online and created their own trust. It looked very beautiful in a binder, it zipped up. When I looked at it, I just had a bad feeling that something was overlooked. And what happened, it was never funded. So basically it was a sheet of paper. We ended up having to probate the estate because the trust was never funded with the real estate. So sometimes saving money, you really don't save money. And that's the purpose of consulting with your attorney to determine what your individual needs are. What is probate? How do you avoid probate? Probate is the process of admitting your will to the court and formally appointing the personal representative, which you may call as an executor. And the court oversees the distribution of the estate. You can avoid probate by adding survivorship options to your property or your assets. For example, when husband and wife own property in Tennessee, we call that tenants by the entirety. So when one spouse passes, the other spouse automatically owns the entire property. Or you may own property with another individual, like a brother or a sister, and we would call that tenants in common with rights of survivorship. So the surviving tenant would own it in full. Or you can have a life estate deed where the parents would own the property during their life. They would pay the utilities, the expenses, insurance, taxes, and on death of the surviving parent, it would automatically flow to the children. For bank accounts, they could either be joint bank accounts or have a pay on death provision. So on death, you present a death certificate to the bank and you're able to take that account, that distribution. Make sure your life insurance policies are current with the beneficiaries. We have had cases come through my practice where the individual never updated the life insurance beneficiaries and the life insurance was payable to former spouses, girlfriends. A trust allows you to avoid probate, and basically when the person that creates the trust, the grantor or the settlor, passes away, we simply administer the trust without intervention of the court. So let's discuss some basics about trust law. We have revocable trust and an irrevocable trust, and I'm using this prop to help you distinguish the difference. So in the first example, we have a revocable trust, which is also called a living trust. So that means that you, as the grantor, the settlor, and the trustee, you can get in and out of your trust as you want to. You can put your house into the trust, and you can take your house back out of the trust. You could put money in the trust and take it back out. And so that's what makes it revocable. With an irrevocable trust, you put the asset, such as your home, that is paid off into the trust. The trust is closed and it basically has a lock on it. And now if you want to get the house out of the trust to purchase a different house, then the trustee, not you, would be able to sign the deed to the property. And that's what gives it asset protection, because you, as the grantor, do not have control over the assets. Ultimately, the beneficiaries, such as your children, will own the asset. So the trust has to be funded 5 years for any Medicaid considerations. So the house that belongs to this trust, if it's irrevocable, would not count as a resource if it was funded 5 years in advance. So it gives you creditor protection. So just remember, with the revocable trust, you can get in and out of it. With the irrevocable trust, the trustee would control those assets. A living trust is what we call a revocable trust. You can revoke it during your lifetime, you can amend it, and you can put assets into the trust, take assets out of the trust. So it's very flexible. I would recommend revocable trust in situations where a person or a couple wants to avoid probate, particularly if they own real estate in more than one state. Otherwise, it'll end up where you need to open a probate in your home state as well as the other states where you own real estate. And it's very popular with people on the West Coast. Now, what it doesn't do is give you asset protection. So I've had some couples to come in that had trusts created several years ago that were under the assumption that with a revocable trust, all of their assets were safe from creditors, and that is not the case. The only advantage of a revocable trust is that you avoid probate and it's easily managed, but it does not give you asset protection. On the other hand, an irrevocable trust does give you asset protection. So whether it's a creditor or even a medical creditor, the state of Tennessee could become a creditor if you utilize long-term care benefits through the Medicaid program. The state of Tennessee could seek a recovery from your assets for whatever money they spent. Or it could be what we call predator protection, where you're protecting your assets from your own family, where maybe there's a grandchild that keeps asking for money from the grandparent, and the grandparent continues to issue distributions from their checking account or savings account. I've had individuals to come in that their estates were depleted by family members who continued to take draws from their parents. You could use a combination of trust where you have a revocable trust, which is the living trust, and an irrevocable trust used together to accomplish different objectives. We still would use an irrevocable life insurance trust in certain scenarios. At this point, at the date of the recording, the federal estate taxes are levied on assets in excess of $11.4 million. And that amount changes year to year, so you'll need to check the IRS website. A Medicaid trust, or we also refer to it as a qualified income trust or a Miller trust, is used to cure an overage. So let's say that you're looking at long-term care for a family member and their income is a little bit over the Medicaid limit. So we can actually send the excess of that income over to a Medicaid trust or a Miller trust so that they could qualify for Medicaid benefits. And then any monies that's left in that trust would be payable to the state of Tennessee, and if Tennessee is not a creditor, it would be payable to the beneficiaries. I would like to speak a few minutes about a power of attorney document. When individuals visit my practice, I feel that it's so important to have your power of attorney, what we call a general durable power of attorney. And this power of attorney allows you to choose a trusted individual to manage your estate if you were incompetent or not capable of managing your affairs yourself. So let's say you don't have a power of attorney and you had a debilitating stroke. No one could act on your behalf to even deal with an electric bill or a cell phone bill without a power of attorney. And that would require petitioning the court for a conservatorship, which could be very costly and time-consuming. So the power of attorney allows you to choose your agent. There's two ways you could set it up. It could be active immediately now when you sign the document, or it could be active on incompetency, and it would require a doctor's certification on your medical status. We could also limit the powers. For example, when it comes to your real estate, we could state that any sale of the property would have to follow the intentions of the will. So if property was sold during the lifetime. Now I think it's very important for elderly couples to include gifting language so that if one spouse is in long-term care facility and incompetent, The community spouse can use the power of attorney document to transfer the real estate over to the community spouse so that they're not passing away owning real estate and end up with a 10-care recovery. So the power of attorney agent would be someone you trust with your money, managing your money, dealing with insurance, taxes, and please be sure to appoint a successor. We also have a healthcare power of attorney and medical directive. Tennessee calls it an advanced medical directive. You can download this document for free from Tennessee's website. So the agent may consent to refuse treatment based on your preferences or to accept treatment. We discuss CPR, do not resuscitate, and other elements of your end-of-life care. A common theme or thread that we deal with when couples visit our practice or they're discussing family issues is that, well, I don't want the nursing home to get mama and daddy's house. They've worked hard all their lives and we don't want the state of Tennessee to take their house. For wealthy clients, it may be a dilemma of dealing with paying for their parents' long-term care because they don't want to see their farm or the real estate caught up in a recovery. And so it may be out-of-pocket expense to them. Sometimes people don't want to discuss dying and end-of-life care. And if the parents wait until they're in their 70s or 80s, it makes it very difficult to do some planning, particularly with a 5-year look-back period for Medicaid. So we encourage you to do advanced planning rather than having a crisis and having to do some very difficult strategic planning at the end. So a lot of families are looking at how do we avoid a Medicaid recovery. So the first step is, remember, the client comes first. How do we adequately care for that parent and make sure they get the skilled care that they need? His or her health is the primary concern in getting that care. But keep in mind quality of life and quality of care. If better care means a nursing home facility, then consider some of these Medicaid issues. So for Medicaid planning, you cannot just give your property to your children. There is that 5-year look-back period. So if you give your assets away, it could actually disqualify you from Medicaid benefits, causing you to be private care. And so we have to figure out what is it that your goal is so we can assist you better. So not pursuing Medicaid eligibility would mean perhaps going into assisted living and paying out of pocket, pooling the resources together so that you're not relying on the Medicaid program. So there's some strategies, pro and con. But let's say it's mom and dad's house, and the statistic is, if you reach a certain age, then it may be likely that you spend some time in long care facility. So how do you get the house and other assets out of your name? Well, that's difficult to do because we have to comply with the Medicaid eligibility rules. So as I mentioned, some people think that they can just give the asset to their children because they're getting it anyway. But the asset is no longer yours. So let's say you give the asset away and your child goes bankrupt and the property is in his or her name. Can you see how adverse that would be to the protection of your property? Or your child divorces and you've put this asset in their name. It's wide open for creditors. It also could be subject to that 5-year look-back period. I had a case that came through where an elderly person's spouse passed away and the individual did not want to remain in the home. They elected to sell the real estate and the parent gave each child a distribution from the proceeds of the house and then moved in with one of the children. Well, 4 years later, she needed skilled care in a nursing home and they wanted Medicaid to pay for it. Well, she was ineligible for benefits because it was within the 5-year look-back period. And so she had a certain length of time that she would have to be private pay to overcome that penalty. And yet none of these children had any of that money left to help pay for her care. Well, what if you just put the property in their name? As I mentioned, that could be problematic if there's divorce or bankruptcy or a lot of debt. So what if mom and dad don't own a home? Maybe they sold their home years ago and they put all this money in the bank. Keep in mind, if you own a home, you're actually eligible for Medicaid. But if you have more than $2,000 in the bank, then you're not eligible. So if you have all this money in the bank, you may want to consider buying a home. Purchasing furniture, making repairs on your home, set up a burial trust, prepaying your burial, or purchase income-producing property. All of these choices should be discussed with your attorney, because making a mistake in estate planning could cause you to be ineligible for valuable Medicaid benefits. It may be that you are planning in advance. Just yesterday, I encouraged a couple to consider purchasing long-term care insurance to help offset those costs. So uncompensated transfers could be where you transfer the property to your child via a quitclaim deed. So if that is causing you to be ineligible for the Medicaid program, they can quitclaim it back to their parent. Or if you gifted some money and that money wasn't spent, they can give it back to the parent. Now, I do want to emphasize, you can be eligible for Medicaid and own a home. But if you sell that home, then it's reduced down to cash, and that can make you ineligible for Medicaid if you're over that $2,000 limit. So it's very, very important that you consult an attorney that is familiar with estate planning and elder law before you make any of these decisions. I appreciate you watching this video, and I hope that it will help you in making informed decisions.